Good evening, everyone, and welcome to ACMI and our first public seminar in Melbourne for the Centre of Excellence for the Digital Child. My name is Luci Pangrazio and I'm a Chief Investigator in the Deakin node of the Centre. We would like to begin by acknowledging the traditional owners of the land on which we are gathered.
Deakin University would like to acknowledge the traditional custodians of all the unceded lands, skies and waterways on which our students and staff come together. As we learn, teach, innovate and research through virtually and physically constructed places across time, we pay our deep respect to the elders and ancestors who have cared for the country that you join us from. An ancient place where education, innovation and knowledge transfer have taken place for many thousands of years. At Deakin, we aim to nurture and continue this important legacy whilst encouraging our communities to walk softly on country in the spirit of sustainability. In particular, we give gratitude to the elders and ancestors of Wadawurrung country, Wurundjeri country, and Eastern Maar country and beyond, where our physical campuses are located. Their contributions to our learning communities and environments are rich and highly valued. Deakin is committed to embedding Indigenous knowledges and perspectives in all disciplines that we teach, as well as advancing the self-determined interests of Aboriginal and Torres Strait Islander peoples, including treaty and truth-telling. As you move around our physical and virtual environments, take a moment to consider, appreciate, and listen deeply to the country beneath your feet.
This is a very exciting night for us. It is the first in a seminar series hosted by ACMI and organised by the Deakin node of the Centre of Excellence. The purpose of the Centre of Excellence is to promote national discussion and information on digital childhoods. We hope that tonight's discussion about protecting children's privacy in the age of datification will make a significant contribution to this debate. Our second seminar will be later this year, and we'll be having 2 seminars a year at ACMI for the next 6 years to discuss important issues around digital childhoods. We see this as a really important opportunity to collaborate with other institutions and organisations, as well as provide the wider community with insights from experts in the field. In addition to the seminar series, we'll be holding a variety of gatherings and other initiatives, so do keep a lookout for upcoming events. Now, before I introduce the session and our host, I would just like to run through some housekeeping. Now, this panel discussion is being simultaneously presented and recorded via Zoom, so we welcome everyone who's online, and there will be time for questions at the end. And those on Zoom will be able to also submit a question via the chat function. Now, this recording will be made available to watch on the Digital Child YouTube channel. After the panel discussion, we would like to invite you to stay on for a drink and to celebrate the launch of Julian Sefton-Green and my editor book called Learning to Live with Datification. Now, we are very privileged to have such an esteemed panel of experts here tonight. Our host is Dr Bunn from Curtin University. Anna is an Associate Investigator in the Centre for the Digital Child, and her work is focused on increasing understandings of legal rights and issues in relation to the use of technology. Anna has written on the impact of technology on children's development and their rights, and has analysed some of the regulatory frameworks governing the use of children's data. She recently provided submissions to the United Nations on the right to privacy and was cited in the report on the children's privacy to the Human Rights Council 2021. I would like to now hand over to Anna to begin the discussion.
Thank you so much, Lucy, and thank you for the introduction. Well, a very good afternoon or evening to you, and a warm welcome to each and every one of you, whether you're joining us here at this amazing venue at ACMI, this is my first time here, or whether joining us online. So I would also like to acknowledge the traditional custodians of the land on which we're gathering here this evening, the Wurundjeri and Bunn people of the Kulin Nation, and pay my respects to their cultures and to their elders, past, present, and emerging. And I would also like to acknowledge the traditional custodians of the various lands across Australia and perhaps even further afield from where our online participants are joining us. So we're here this evening to talk about children's rights in the digital environment, specifically the protection of their personal information and data privacy. The conversation, I think, is more important than ever. So we know that staggering amounts of personal information or data, that is information that's related to an identified child or which can be linked back to a particular individual child. Staggering amounts of this personal information is collected every second of every day. Now, there's no doubt that many of the uses to which the data is put and the insights it generates can be enormously beneficial to children, to their families, governments, of course, business and society at large. But some of the ways in which data is collected and some of the uses to which it is put does give cause for concern. So the collection and analysis of large amounts of data about an individual child can be used to build a detailed profile of that child, and in turn those profiles can be used to shape opinion and influence behaviour, such as by way of targeted advertising. So some of the information collection practices and data usage practices raise concern about children's privacy, about their freedom, and in some cases even their personal safety. We know that, in the words of UNICEF, children are more vulnerable than adults, and they're less able to understand the long-term consequences of consenting to data collection. I think children are also vulnerable because of the fact that, being young, the data trails that they'll leave over the course of a lifetime are obviously going to be long and rich. And of course their lives are so enmeshed with technology. Now, we know that children, or many children, do care about what happens to their data, and they've expressed their wish to know what is collected, how it's collected, and what is done with that information. And some children have also expressed anxiety over what happens to their personal information. We also know that parents worry. So in the most recent survey on Australian attitudes to privacy from the Office of the Australian Information Commissioner, they found that approximately 70% of parents said they were uncomfortable with businesses tracking the location of a child or selling their personal information to third parties. And over 4 in 5 parents believed that children should have the right to grow up without being profiled or targeted. Yet just last week, Human Rights Watch released a report. They reviewed 169 educational technology or ed-tech products. They found that 89% of them appeared to engage in data practices that put children's rights at risk, contributed to undermining them, or actively infringed them. So, for example, among other things, Human Rights Watch found that most online learning platforms installed tracking technologies that trailed children's internet use even once they'd left the digital virtual classroom. And also that most platforms granted access to children's data to third-party companies, usually advertising technology companies. So that report was about edtech, and of course edtech is just one of many sectors with which children engage in their day-to-day digital lives. We know that children have a right to privacy, and the right to privacy has been interpreted as including a right to protection of their personal information, and that right to privacy is enshrined in the Convention on the Rights of the Child, as well as in other international treaties. But children, of course, have other rights too, and sometimes they need to be balanced against the right to privacy. Importantly, children have the right to seek, receive, and impart information and ideas, and they also have a right to development. As the UN Committee on the Rights of the Child has recently noted, opportunities provided by the digital environment play an increasingly crucial role in children's development and may be vital for children's life and survival. It also noted that meaningful access to digital technologies can support children to realise the full range of their civil, political, cultural, economic and social rights. So the question, I think, then is, and to use the words of the UK's former Information Commissioner, how do we protect children not from the digital environment, but within it? So that the UK's age-appropriate design code, which is colloquially known as the Children's Code, seeks to do just that. It's a statutory code of practice that came into force in 2020, and it's been described by some people as groundbreaking. But what does the code of practice mean for UK children in practice? How does the position of Australian children compare with those of their UK counterparts? What might we learn from the code itself and its implementation? And what can we do, whether as individuals or within our teams, do to further the protection of children's data within the digital environment? So to hopefully answer some of those questions and more, I'm so delighted that we're joined by our panel of guests. So I would like to first of all introduce, and I believe joining us online, there we are. Welcome, Emma. So joining us online, I think from Portugal, is Emma Day. Emma is a qualified lawyer specialising in children's rights and technology. She holds postgraduate qualifications from the UK, US and Canada, and she currently consults for UNICEF as well as for other non-profit organisations. So welcome to you, Emma. And
Thank you.
With us in person, I'm delighted to introduce Sven Bluemmel, Victoria's inaugural Information Commissioner, and himself a qualified lawyer, I understand. The Commissioner's held numerous public sector appointments, including as a former Information Commissioner for Western Australia. It's also really exciting that we're joined here in person by Dr Rhys Farthing. Rhys is the Director of Data Policy at Reset Australia, a not-for-profit charity working to raise awareness and advocate for better policy to address digital threats to Australian democracy. In this role, Rhys has led the campaign for a children's code in Australia, and she's also worked as an academic, as well as for non-profit organisations and think tanks in Australia, UK and US. I think we're lucky to have you here in Australia at the moment, Rhys, because usually she's based in London. And last, but of course by no means least, I'd like to introduce you to our very own Associate Professor, Cathrine Neilsen-Hewett. Cathrine is the Academic Director of the Early Years at the University of Wollongong and also an Associate Investigator with the Centre of Excellence for the Digital Child. So thank you very much, all of you, for spending some time with us this evening. So I'm going to begin now by addressing some questions to the panel. And when I've done that, we'll open it up to questions from the audience. So Emma, if I could start with you. Emma, could you just please tell us a little bit more about the Children's Code? What difference do you think it will make for children in the UK? And have we already seen any changes to the way that online services operate as a result of the code's introduction?
Thanks so much. And thank you for inviting me to join this really important panel. It's really great to be able to participate in this and happy that you're having this conversation. So to answer your question, the Age Appropriate Design Code, or the Children's Code, is a statutory code in the UK, and it came about through an amendment to the Data Protection Act, and that's a law which implements the GDPR in the UK. And the amendment to the Act required the Information Commissioner to create an age-appropriate design code for children. And the code contains 15 standards that online services need to follow to ensure they're complying with their obligations under data protection law to protect children's data online. And so I'm not going to go through all 15, but some of the things the code requires companies to think about is mapping what personal data they collect from UK children, assessing the age of their users. And this is an area that's still under discussion about how you can assess age of users while still protecting their privacy. switching off geolocation services that track where in the world their visitors are, not using nudge techniques to encourage children to provide more personal data, and providing a high level of privacy by default. The code applies to UK-based companies and non-UK companies who process the personal data of UK children. And it applies to information society services likely to be accessed by children. So the code doesn't introduce any new obligations for companies, but rather it details how they should comply with data protection law in the UK when it comes to children. So although it's not a new law in itself, a breach of the code could form evidential basis for a successful argument that the UK GDPR has been breached, which may lead to significant enforcement actions, regulatory fines, and civil claims. The code's officially enforced by the Information Commissioner in the UK. So the ICO, the Information Commissioner's Office, says they will ensure proportionate and effective regulation by targeting their most significant powers, focusing on organisations and individuals suspected of repeated or willful misconduct or serious failure to comply with the law. The ICO has the power to fine infringers up to £17.5 million or 4% of their annual worldwide turnover, whichever's higher. And they can issue orders banning data processing or otherwise requiring changes to services they deem non-compliant. There is already some evidence of impact. So it actually only came into force on September 1st, 2021, because there was a grace period in which companies could comply. But prior to that date, we saw Instagram, YouTube and TikTok all announced changes in their handling of children's data and in account settings. None of these companies specifically mentioned the code, but it was clear that they all acted prior to it coming into force. The ICO is taking this targeted approach. So the question, I suppose, then is does this feel like a threat to all companies, particularly smaller companies? So it's very difficult to make that threat feel real right across the whole technology sector with limited resources that any data protection authority has. So like most data protection authorities, the UK ICO does have limited resources, but I think when we look across Europe, at least, they're doing better than some. There was a survey done in 2020 from the European Data Protection Board of the data protection authorities throughout Europe. And the UK's budget was twice that of Italy and 3 times that of France. So what I'm trying to stress here is that the resources do have to be put behind this kind of code to ensure enforcement. And you will see that the ICO is quite active in this space subsequent to the code, producing other materials to try to help with the enforcement. There has been some confusion about whether or not the code applies to children's data processed by edtech companies in schools. And there have been some civil society organisations who've had some back and forth with the ICO on this. And this is really comes down to whether or not edtech companies are seen as information society services in the school context. And that's not totally been resolved yet. But this is quite a big gap that's possibly a learning to take from that to make sure that edtech does come within scope, particularly given, as was mentioned earlier, what's coming out recently, for example, by the Human Rights Watch report. One of the things that the ICO has done to sort of assist with enforcement and implementation is they have a regulatory sandbox. And in 2020, they had a focus on children's privacy within the regulatory sandbox. So they had a number of companies who were able to test their products with the support of regulators in a protected environment, because technology is moving so quickly, to allow for companies to not divulge all their trade secrets, but still be able to experiment a little bit with regulators. I will leave it there. I don't want to talk for too long, but I hope that answered your question.
Oh,
Thanks.
Thank you. Thanks, Emma. Yeah, and I think it's sort of interesting and good to know that despite some of the challenges with resourcing and so on, that there has been some evidence of impact already. Emma, when the code was first introduced, the UK Information Commissioner's Office said it hoped that the code would set a standard for other regulatory bodies around the world to follow. So can you tell us to what extent that is the case? Have other jurisdictions moved to adopt similar models?
Yeah, so I think it definitely has set a standard. So following the UK code, we saw in Ireland the Irish fundamentals produced by the Data Protection Commission, recommendations on children's data coming from the French CNIL, the Data Protection Authority in France, and similar codes in the Netherlands and now California. However, I believe the UK code so far is the only statutory code that's actually binding and enforceable. We have various pieces of policy guidance, so we don't yet know to what extent that will make a difference in terms of how enforceable and easy to implement these codes are. There are also, I think that the Children's Code started a kind of momentum. So the European Data Protection Board is also now embarking on drafting a children's code for the whole of Europe. And that will be a process that takes a year or possibly two, and will be subject to public consultation. And then that will produce authoritative guidance on how the GDPR should be implemented for children across Europe, which is likely to have significant impact across the world because of the market size of Europe. And we can see Europe has significant influence at the moment in terms of data governance in general. In addition, I think that the UNICEF Manifesto on Good Governance of Children's Data, which is a publication I also worked on last year, has had some influence on data protection authorities around the world. And in terms of standard setting, the Five Rights, who were a big pioneer behind the Children's Code, have been pushing to start a process of actually creating a standard with CENLEC, who are a standard making body, which will be an age-appropriate design standard that can be used, hopefully beyond the UK even. So I think what we're seeing is that governments are increasingly seeing that self-regulation is not enough on its own from industry, and children's rights are becoming a core area of work for data protection authorities around the world. So it's definitely spurred something of a movement, and I think it's going to become not an option anymore for data protection authorities to ignore children.
Great, thanks, Emma. I think it's great to hear there is that momentum in Europe, but also elsewhere too. If we could just now come to Australia, and I might ask you, Commissioner, could you please briefly outline some of the similarities and differences between the Children's Code in the UK and the current position in Australia in terms of the protections specifically offered for children's personal information?
Sure. Unfortunately, there are far more differences than similarities. In fact, there aren't many meaningful similarities. In Australia, the way it works, like of course it does in many federated systems of government, is we have a National Privacy Act, which of course regulates the parts of the private sector. There are large exemptions from it, as well as the Commonwealth public sector, and then most states and territories have something that applies to their state public sectors, and in Victoria that's the regime that I effectively administer under the Privacy and Data Protection Act here. The similarities, as I said, they're few. Some of the sort of similarities are, which we've already heard mentioned, the obligation to look at what data is actually collected, how it flows, how it's kept in custody, how it's used, and so forth. In Australia, that's the sort of thing that you would usually do in what we call a privacy impact assessment. But even the law here doesn't actually fundamentally require you to do that. There is a lot of guidance from data protection authorities, mine in Victoria included, that either highly recommends or in some cases for certain sectors effectively mandates the undertaking of a privacy impact assessment. So there's some of the sort of similarities, but in terms of anything specific for children, there's essentially nothing that's binding, nothing that comes close to a code, let alone a statute. The way that children are in some ways highlighted, or their needs or vulnerabilities are highlighted in Australian privacy law, is generally through guidance material from the regulators. The big differences, I'll just pick on two that I think are the most important as far as I can see. First is the requirement under the Children's Code that the well-being or the rights of the child are effectively paramount in your consideration. Now, there's nothing at all like that in Australian privacy laws at all. And another one is that in the code, the regulated organisations are not to use data in a way that's been demonstrated to be against the well-being of the child. Again, there's nothing similar to that in Australia. The reason I highlight both of those is because to me they go to a sort of fundamental different conception of how to approach privacy regulation and privacy protection. So in Australia, like in fairness, like most places in the world that have privacy regulation or data protection regulation, we think of it as very transactional. We think of it as there are all these autonomous human beings and they make choices on a case-by-case basis on whether to sign up to a service, whether to click I agree, whether to set the cookies to this or that, and then they click OK. Now, that's bad enough, and I think insufficient enough even when we're talking about adults. Because, I mean, again, it's a classic question. How many of you have read the last privacy policy for a service that you needed then and there? And that's what our laws are largely, but not exclusively, based on. They're based on transaction and they're based on informed voluntary consent. Now, something like here, like the Children's Code saying, no, the interests of the child are paramount, completely goes beyond that, and in a good way as far as I'm concerned. Because, again, I say even for adults, I mean, imagine how hard it is for a child to do that. I mean, those of you that have got children who sign up to stuff left, right and centre despite your best efforts, they're not going to read that. How many times have you been asked to agree to something on behalf of your child? And on those cases, have you felt like you've really had meaningful agency to say, oh yeah, I've got a valid choice here, I'm going to see which way I go? Try telling that to your child to say, no, you can't sign up to this. Good luck, especially if they're a teenager. So it's conceptually different. That's why I highlighted those two, because they're not just questions of degree or questions of expression, they're questions of fundamental approaches. And I think it's actually quite refreshing to see this happening, because it sort of starts to challenge the kind of techno or data exceptionalism. This idea that, well, this is all data, you can't really regulate that like we regulate other stuff. Well, why not? I mean, none of you here today coming into the building were, I assume, presented with a choice of saying, well, here are the safety features of this building, and here's the sprinkler system, and here's the evacuation system. There's still a remaining risk. Sign here if you accept that risk and want to come in. None of you had to do that. And none of you should have to do that, because building occupation is regulated to a certain extent, to a large extent. And therefore, if you own a fire trap of a building, you're not allowed to have events like this. And yet, when it comes to things like data and privacy, we sort of, in a political sense, still tend to be a case of, well, no, it's all free market. It's all up to you. So the similarities are fairly minor and not particularly exciting. The differences are fundamental. And I hope that they just start to sort of, push the door ajar a little bit, and we can start, as regulators, getting our feet in that door and hoping that we can get some better outcomes and challenge some of the transactional orthodoxy. And I think if we think of it much more like other areas where we're quite comfortable regulating, clean air, environment, water, fire safety, pharmaceuticals, all of those sorts of things, where we don't even pretend that an individual should be able to compete with big pharma in making a decision about whether a certain drug is safe or not. We go, well, no, we've got testing regimes for that, and we've got regulators for that. So that's where I see the big fundamental differences.
Thank you. Yeah, I think it's sad, but I guess given what you said about the way we conceptualise privacy protection, not surprising that the position of Australian children is considerably weaker than in terms of data protection than their their UK counterparts. Thank you. Cathrine, if I could turn to you, do you have a sense that educators, particularly in the early childhood sector, are concerned about the use and collection of children's personal information when they're using apps or online services? And if so, do you think that actually impacts on what services are used in the classroom?
Yeah, I think there's significant variability in the sector in terms of educators' understanding of data use, of data storage, and the journey that children's data takes. But I do want to preface that I'm not the voice of the sector in answering this, but in terms of the educators that I've spoken to, on the continuum of understanding, the majority do not understand what happens to the data in terms of the data that's linked to apps, the data that's linked to digital platforms. But what I do see amongst the sector is a strong sense of uniformity in terms of their commitment to children's safety and security and wellbeing, and that's our platform from where we stand. And I think if we extend on the conversation that we're having around children's rights, I think that's important, because if we look at high quality pedagogy and practice within an early childhood context, it really prioritises the security and the safety of young children, but it also prioritises children's learning and development. And I think we need to think about where the code sits in terms of children's learning and understanding. And we know that educators are very skilled at working in partnership with children and with families, and they have the best interests of children at heart in terms of their decisions, in terms of their planning, in terms of their practices. But that's very much informed by their understanding of children and their understanding of the context. And I think that's where the challenge lies, because while they understand the non-digital context, they do not have a very good understanding of the digital context. And we are in such a fast-moving environment. And so I think many of their decisions are informed by a lack of understanding. And so I think we've talked about the code as protecting children, but in some ways it might actually protect educators, because they may be inadvertently making decisions that are actually placing children at risk in terms of their privacy and their learning. I do want to say, though, that, and this is a bit around digital citizenship, I think educators are already engaging in practices that are underpinned by the recognition that they really need to support children's citizenships and needs within those digital platforms and contexts. So they already seek children's permission to show photos. They already seek their permission to share information with families. There's policies and practice that guide that. And this is very much around Story Park and Kinderloop. But I think the challenge lies in the use of apps. And educators are overwhelmingly unsure around what apps to use. But I'll say that uncertainty is not really underpinned by a concern for data. It's underpinned by a concern for the pedagogical value of the apps that they're using. So a classic example was an educator that I was talking to shared an app that she'd used with some young boys, and it was a puzzle app. And she used it because the boys weren't engaging with puzzles in the learning environment. And so she wanted to think of a way that she could get them engaged and excited. Now, this app, she chose the app because it really empowered children and gave them a sense of agency. And what they got to do is they got to take a photo. And so these boys took a photo of each other and they uploaded it into the app, and then they started playing around with that on an iPad. 2 months later, they were doing 100-piece puzzles on tables. So she valued that. And I said to her, "Did you ever worry about what happened to that photo?" And she didn't. She said, "I just trusted that wherever it went, it was looked after." So I think the context around this is really thinking about how do we situate this within a broader framework of practice. So for me, the code kind of sits at an intersection between children's right for privacy, but also their rights to a holistic education, and their rights to have a voice. And I think that's critical from an early childhood perspective, is that we really work towards empowering the voice of children. And so if we think about how that's going to work from an early childhood perspective, I think we need to think more broadly.
Thank you. Yes, I think you've probably partly answered my second question, or maybe entirely answered, but just basically quickly, so do you think the sector would be in favour of the introduction of a children's code similar to the UK's code? And maybe you can also comment on what it might mean for parents and children themselves.
I think in principle, the sector will be supportive of anything that protects the rights of children, and that's the rights to privacy and rights to education. I think my hesitation, and I guess the question for me is the risk of not having a code greater than the risk of having a code? And so what are the implications around that? So for me, within the early childhood platform, there's still real reluctance to embrace technology. And in some services, you'll find educators who are not using technology at all in the service. In fact, I had a PEC supervision meeting yesterday with a fourth year who was wanting to use WhatsApp, and there were 2 educators in that service who didn't even have a phone, a mobile phone. So I think there's real danger that something like this, if it's introduced and there's not education around it, that it actually may impact on children's rights to a holistic education. And we saw that in around the safe standards and play, where many educators have become very risk adverse around children's play in outdoor environments, and it's impacted them negatively. So it has to be introduced within a framework of understanding. And I think the same is with parents. And so if we're going to bring this in, it needs to be around information. It needs to be information around cyber safety, around the empowerment of children and the empowerment of their voices. But I will say that there are concerns that educators do share around what I call sharenting, the sharing of information. Now, there are a lot of policies and practices that educators have to abide by in terms of what they share on Storypark or Kinderloop. So a parent may say, I'm happy for you to put my child's picture on Storypark, but I don't want you to share it on your Facebook. And so they do that, but then other parents will capture that image in Kinderloop or Storypark, and then they will share that on their Facebook. So I wonder whether a code will protect that from happening in terms of the concerns and sharing of information. So I think there's some of the things that we need to think about more broadly.
Yeah, I think you do make some really interesting points there, and it is about that broader education as well, isn't it? Striking the right balance. Rhys, if I could come to you. Bit of a long question. We know that the former Australian government now has proposed the introduction of an online privacy bill, which it's already released a draft of. And it also began a review of the National Privacy Act with a view to strengthening some protections for children's personal information. So first thing is, do you have a sense, you might not, but do you have a sense of how committed the new Labor government is to these reforms? And on the assumption that they will progress, and in their current form, could you briefly outline what difference you think the reforms will make? Do they go far enough?
Yeah, okay. That's a sort of both a long and million-dollar question, I think. And I think it's sort of definitely worth thinking about that in context, where we've almost got Australia's entire sort of privacy framework up for an overhaul, which absolutely creates opportunities for policies like this, but it also creates risks. And there's definitely 2 of these kind of opportunities/risks that are sort of worth mentioning. I think the first is definitely worth keeping in mind, the sort of much needed review of the Privacy Act that's happening. And I say much needed because, fun fact, the Privacy Act was passed in, 1988? Yep, so a full year before the CEO of Snapchat was even born. So definitely it was never intended to address the type of intensely datafied world that our children and young people grow up in. So we've got that sort of much needed review happening, but that review commenced, I sort of wrote the date down here, commenced in December 2019, so 2 years and 7 months ago, and it's still ongoing and we still haven't seen it. And if that feels like it was a long time ago to sort of think about the second policy risk or opportunity, you've actually got to cast your mind back even further than that. So you've got to go a full 3 years and 3 months ago to March 2019 with the then Attorney General, Christian Porter. Do you remember him? The one sort of 3 Attorney General, well, technically 4 Attorney Generals ago, announced that an online privacy bill was coming. And this would be the bill that would pave the way for a code that would cover all Australians' data, including and especially children and young people. But we've been waiting 3 years on average, you know, for those. And so I can't definitively answer the question of will they be enough? What difference will those reforms make? Because we're yet to see it come to fruition. But if we want to speculate a bit, there's a possible optimistic vision of what could happen, where the online privacy bill, the one that made it to, as you mentioned, a draft exposure phase, and there was a greatly improved second draft that went to Senate, I think just sort of dropped on their desk just before the last election. And that potentially has enough in it to see something resembling a children's code developed. It would be a code that's centred around how we use children's data in their best interest. And that's the sort of rights-based principle that, Sven, you were talking about as much needed. And that's the sort of starting point that we want. So that is a possibility. It absolutely, as a piece of legislation, had some difficult pieces and a very limited scope too. But I think in this is the optimistic vision I'm outlining here. It would kickstart the process of navigating towards a code. And you can see a world where, as Australia is sort of developing that code, as it's being drafted, you know, some strong scrutiny and clever campaigning could sort of push that code closer to what's emerging as a kind of global norm around what children's codes look like. So we could end up with something that looks similar to the UK, to Ireland, to what California's developing. But that was a sort of optimistic vision. The sort of second alternate, if we want to be a slightly pessimistic soothsayer instead, there's two really large policy risks facing us right now. Firstly, as you mentioned, the change in government, right? Like, this was a draft piece of legislation drafted by a government that's no longer in power. And it is unclear if the new Attorney General's office is going to take a kind of slash and burn approach and not pick up anything that was drafted before. I'm not 100% sure, like I don't feel like that will be the case. We had at Reset, we had some very detailed conversations with both the Labor Party and particularly with Mark Dreyfus's office when he was Shadow Attorney General. And there is support for regulations like this. There was support for this particular bill. There was support for something akin to a children's code. So I think it's unlikely that it will be completely dropped without anything being put in its place. It might just be a question of time. But then there's the obvious risk in Australia, which comes from our Privacy Act framework that is yet to be, you know, completely reviewed, is that if this code goes ahead under that bill in that format, it goes to industry to draft in the first instance, which is just a sort of a bit beyond the pale, should we put it that way? And so there is the capacity there, whether this is an opportunity risk, I don't know. There is the capacity that the new government might move towards something in primary legislation instead, and that isn't as far-fetched as it seems. There was actually in the previous government, you know, a couple of ministers who were quite interested in putting forward primary legislation until the second new Attorney General Michaelia Cash revived the sleepy enhancing online privacy bill. So it is possible that that could happen, or it is indeed possible that the Information Commissioner's Office will decide, possibly be encouraged to decide, that industry does not hold adequate expertise in children's best interest and that they would not be, therefore, the best people to develop a code. But what difference the online privacy bill can make is really going to depend on which of those paths we go down. If we get a few good decisions happen, if we're sort of running downhill, then you can absolutely see there is a pathway, there is a clear pathway to an Australian version of a children's code. But if the bill is shelved or it goes to industry to draft in a kind of unscrutinised, pretty lax fashion, then I think what we're going to find is we've got yet another missed opportunity for Australian children and young people in the digital space.
Well, all I can say is we can but hope, and we're relying on you, Rhys, and your organisation. Commissioner, so maybe just to quickly pick up on that point about industry, there's a possibility of industry drafting a code. In your view, would that be a workable solution or proposal?
Technically workable, probably yes. Desirable, no. Absolutely not. I think, I mean, there's a clear case of moral hazard there. Some of the organisations that would have the biggest impact from an online privacy code have business models that rely on the monetisation of personal data. And that, to me, is fundamentally inconsistent with being able to draft a code that would actually achieve the objects that society as a whole would seek from it. And my office made that point in our submission to the Online Privacy Bill. That's all on the public record. And in that submission, we did point out that, of course, looking at some litigation overseas, the Fair Trade Commission in the US, there is a history of some of the big players in this space not playing nicely. And therefore, to trust them to develop the code seems unwise, I would say.
Yeah, thank you. Well, it'll be interesting to see what happens, and hopefully something at least happens soon. Just so my final question then, Rhys, your organisation has done some work with children and young people. What concerns have they expressed about their personal information, and how should their voices inform the development of the Online Privacy Bill or other changes to Australian laws?
That's almost as tricky a question there. But look, definitely one of the things that we noticed when we spoke to children and young people was an absolute sense of almost apathy or an expectation that, of course, their data will be exploited. So when you opened up the conversation, you know, the first answer you got was, this is just the way it is. Why would I care? Why are you talking to me about this? Which I think is an absolute sign of how far big tech has won the narrative about what is possible, about framing that debate. But when we opened it up a little bit further and we kept the conversation going and we said, look, imagine, do you want it to be a different way? If you could change things, would you? You got a whole different set of answers coming from young people. Young people really didn't like that feeling that they were constantly being watched, that they were non-stop data labourers and that other people were making money by constantly watching them. And so they kind of had this innate value of the idea of privacy, even if for many of the young people we've spoke to, they've never had it. And I think that's really important to think about when we frame the idea of how young people should engage in these discussions. We may need to hold some space for them to have really informed deliberations. You can't just ask one question about privacy, what the rules should be, you know, cold and leave it from there. Because this is a really unfamiliar concept for young people who've grown up datafied from birth. We're asking them to imagine the world they want as a world that they have never lived in. And that's not an excuse not to consult with them, just a call to sort of do it thoughtfully. They absolutely have clear ideas about what they want the rules to be. They absolutely want privacy from big tech. They value this. But they absolutely also want to have a say about what it looks like. So I think it's going to be a really interesting code development process in terms of engagement with children and young people.
Yeah, thanks. I think they're very important points, and you know, it's significant how we actually go about consulting with children, not just whether we do so. Yeah. Look, thanks very much, panel, for the responses to questions. I'd like to open it up now to the audience. So I'll go to people in the room first, and if you do have a question, please just raise your hand, and someone will bring a microphone to you so that the online guests can hear your question as well. Any takers? Thanks, Sue.
So this might be a question for the lawyers, and I'm thinking about the way laws are drafted with all kinds of wiggle room in them. So how do we actually work out who decides what's in a child's best interest? So I mean, practically. Surely that's a challenge. It's open to interpretation. How are we going to discover this and arrive at some agreement about who gets to decide?
I'm happy to start us off. It's a challenge, and it's going to be really, really hard. It's going to be controversial, and it won't always be gotten right. But all of those concerns apply to other kinds of regulation that we think are appropriate in terms of what's reasonably safe. Lots of laws have in the best interests of this or that in them, and none of which is to say that it's going to be easy. It's absolutely not. But it doesn't stop us elsewhere from saying this is important enough that we're going to have to wade into that thicket with some guiding principles like, well, not even guiding principles, but requirements in the best interest of the child. Yes, we're going to have fights about those on individual cases, absolutely. But that's a great place to start, because I think we could all agree on that that's more important than the interests of the shareholders of a particular company that's exploiting children. And let's get in there, knowing it's going to be hard, but it's worth it.
Thank you. Emma, would you like to add anything?
Sure, thank you. Yes, I mean, I would agree with that. I think the concept of the best interests of the child comes from the UN Convention on the Rights of the Child. And it can be, I think, a phrase that's battered around, that sounds as if anyone can just decide what they think is in a child's best interest. But there is some guidance from the Committee on the Rights of the Child on how you make that decision and how you balance all the different child rights in the convention to find something that is overall in the child's best interests. But we do need more detailed guidance on how that applies to the technology sector. And I think more guidance needs to come from regulators rather than allowing companies to make it up for themselves.
Familiar theme. Thank you. Any more questions from the audience? Thank you.
Thank you. I was just had a question about privacy, not just from big tech, but from parents and teachers, and how children, what rights children have to that level of privacy and anonymity, and how anonymity might fit in with this code.
Reece, do you want to take that? Or?
Yeah, sure. I think that's really interesting, and that's definitely one of the sort of hot topics that you have when you talk to parents about this, is like, oh gosh, privacy from, but maybe not necessarily from us. But it's interesting that the code, codes as they've been developed in different countries actually do attempt to sort of assert children and young people's right to privacy as a sort of evolving principle. So one of the things that the code in the draft code in California proposes, and the code in the UK sort of proposes, is that actually where you have parental controls, it needs to be clear to children and young people that they're turned on. So children and young people need to know what's viewed and what's not. And I think that I was speaking to a young person who was actually a co-speaker at a conference with me. He was 10. It was fantastic. And I asked him what he thought about geolocation tracking. And he was talking about the Families Tracking app that they have, where they can see where they are. And he said it was good because it made him feel safe and he knew where his family was. But what he did not like about it, the specific thing was, he didn't know when his mum was tracking him. And so his way of asserting equality and rights within that was that he used to track his mum back when she didn't know as well, so that there was at least that sense of fairness. But I think it is important to sort of recognise that actually, if we are talking about children and young people's privacy and what's in their best interests, one of their best interests is the evolving capacity, the right to anonymity, the right to privacy, within different settings aside from commercial exploitation, and that has to be factored into it.
Thank you.
I think I'll just add to that. I think if we're thinking about, a lot of this discussion is around how we can contribute to children's safety and wellbeing. And I think some of that is around privacy, but it's also around supporting self-awareness, and that's developmental. So what privacy looks like within the context of relationships changes as children develop. And I also think it's about developing those conversations. So we call it Stalker app in my house, and I have Stalker app, but only on 2 of my children, because one of my sons just doesn't want me to have that, and out of respect, I don't. But from a parent perspective, I think, it's such a challenge, and I think when we're supporting children, and our role is to keep children safe, But there's such a power imbalance in the digital world because my children know so much more about what's happening in that space than I do. And yet, so in many ways, I become the learner in that environment, and I'm the student. And I think that adds a layer of complexity as well around those conversations of privacy and respect. But I think regardless of whether we're talking about digital platforms or the real world, we actually need to prioritise relationships and the voice of the child or the adolescent.
Thanks very much. Two questions, I guess, to the panel. The first has to do, I guess, with the right of erasure. So, I mean, how does that kind of come in, to that spectrum of childhood development when we would expect children to choose to erase all of these, the outcomes of the last 3 years of my education or whatever it would be. And the second, reading very briefly the code, it seems that it is designed in a way that's very non-technical. There's no kind of technical lines in the sand. So I just wondered if that was a design feature, the reasons for presenting it that way. Example, no need to encrypt your data or provide anonymity to that kind of thing.
Emma, did you want to take that question?
Sure. I think probably maybe answering the second part first. I think the reason it's not so technical is probably for longevity, because technology changes so quickly. So I think that's why there's now also a move to have more technical standards, which will address in more detail how you actually implement the code from a technology sort of design perspective. In terms of the right to erasure, that is a right within the GDPR, and so it's a bit difficult for children because it also comes down to consent, and again comes down to the evolving capacity of the child and the relationship with the parents. But children do have a right of erasure, and there should be mechanisms in place for children to request that right themselves. I don't know how far that has been translated into practice, and I think it's quite complicated because sometimes that even if that data is erased, it may have been processed in a way that then will have implications that go into the future, even if you erase that specific piece of data, partly for the individual child and maybe for children as a whole. For example, if that data has been used to train an algorithm, or in other ways of processing which have implications for society and groups of children, that's an area where there's some limits to what personal data protection laws can address, I think, in terms of the impact on children's rights. But yeah, the right to erasure certainly exists. I think it hasn't been followed through enough yet in practice by technology companies to make that really achievable for children. The technology companies need to have the mechanisms in place and would need to employ the staff to be able to implement that on the company side as well.
Thank you, Emma. We might take one more question from the audience. Thank you.
Thank you. I want to ask a question about the child's voice, literally. I do work around voice assistants and wonder whether you have any thoughts on how voice interaction and voice data can be considered in regards to code and regulation, especially thinking about often, like in terms of voice assistants, the person whom it's registered to is not usually the only user of them.
I mean, in particularly also considering it's biometric data, right? Like that's identifiable. Now, Sven, you will correct me if I'm wrong here. I don't think that the Data Protection Act has, the Australian one, has enough protections for biometric data, or even does it define voice as a type of personal information, or
the Federal Act, I'm not sure. I don't think it does.
Yeah.
And even in terms of the broader question of dealing with biometrics, I mean, it really, I agree with that broadly, that it doesn't provide enough protection for those sort of special categories. It defines certain things as sensitive information, which then are not treated fundamentally differently, they're treated differently by degree. And I think that's the big difference.
Yeah, I mean, I just think it's a big gap in the Australian framework, and whether or not a code can deal with it is going to depend on what type of code we get, and particularly the scope of the code, because we, again, a quirk of the Australian system, our codes will need to be limited by, to a specific sector, to a specific piece, and whether or not they cover biometrics is going to depend on what happens next. So it's a gaping big hole that we've got at the moment.
And just to make the whole thing even scarier, deepfakes. You start getting voice, you start getting image, you start getting video, and all of those sorts of things. I mean, the stuff that can be done with that, with remarkably little sampling, is pretty scary.
Scarier and scarier. Thank you. They're great questions from the audience. Thank you very much. Before we wrap up our session then, I might just ask each of our panel members, and I'll start, Emma, with you, if you could just make a short closing statement about the extent to which you're optimistic or otherwise that we can strike the right balance between empowering children and protecting their personal information within the digital environment. Emma?
Thank you. I am very optimistic, actually. I think there's such a momentum globally in so many countries to learn from. It's quite a good position to be in if you're now at the process of drafting something and can draw on examples from around the world. And there's also, of course, General Comment number 25, which came out last year as well from the Committee on the Rights of the Child, which has really good advice to states about regulating the technology space for children. So I would be on the side of maximum optimism here, I think.
Great. Commissioner?
Yeah, thank you. I'm also optimistic, but I think that's sort of just my nature. As anyone who works with me will testify that it can be quite annoying at times. But I am optimistic, and for similar reasons to what Emma mentioned there. Every sort of revolution seems impossible until it's inevitable. And while it's not inevitable yet, I think some of the sort of those shibboleths that have been around, like, well, you can't regulate big tech or big data because we'll lose innovation. And this sort of, I've already mentioned before, this techno-exceptionalism or data exceptionalism. No, this is different. You can't regulate this country by country because it travels around the world and all of those. So yeah, that's all true. But that doesn't mean we can't do anything. And as the world's not going to come together and regulate this in one big coherent way. That never happens. The way it'll happen is that, in this case, the UK, maybe soon California and others, will just push the door open enough to say, well, we're trying it. And then when the sky doesn't fall in, others will go, oh, maybe that's now actually possible. And we saw that with regulation in things like CFCs, lead in petrol, all of those sorts of things. Maybe we'll see it with plain packaging cigarettes, all of those sorts of things. Some jurisdiction goes out and says, no, the time's right, we're going to give this a go. And then the sky won't fall in and others will come along. And I think we're in a similar place here. So I'm also optimistic. It's not going to be easy, but I'm optimistic.
Thanks, Reese.
I'm not actually sure we need to strike a balance between the two. I mean, isn't protecting, personal information part and parcel of empowering young people to realise their rights in a digital world? Like, I think it's, there's no balance to be struck between them. It's the same piece. It's about pushing forward on it. But if the broader question is, can Australia kind of regulate to realise young people's rights in a digital world, then I think I also share people's optimism, which is unusual for me because I'm a deep pessimist. But we've had huge support across civil society. When we work with children and young people, they tell us this is important. When we speak to politicians across parties, there's a lot of backing for it. Civil servants. We've even had law enforcement agencies sort of approach us saying, we think this is a great idea. Everyone seems to be keen on it. And so I think all of the elements of success are there. It's just a matter of finding the right regulatory route to capitalise on this. And again, I don't think that's going to be a small feat, particularly given Australia's interesting approach to regulating the digital space, but I think we can absolutely get there, and I feel like possibly this might be the issue to get us across the line and show us how it's done.
Thank you. Cathrine?
Well, I feel like I should give you a full hand and go with the optimism. I'm going to say I'm quietly hopeful. And just off your comment, Reese, about the empowerment of voice, that's what I'd really like to see, is where I think we can do things differently in Australia. And I think we should think about not just about what the code looks like, but how we get there and what voices do we empower, and that sense of ownership as part of that. And I just want to touch on something that you said at the beginning around the purpose of the code, which was around protecting children within digital environments and not from. And I think anything that, from an educational perspective and from a parent perspective, that frees educators up or parents up to create rich experiences for children, then that has to have my vote, I think. So.
Great, thank you so much. Well, I'm sure you'll all agree that we've had some really valuable insights from our panel members, lots of food for thought. I thought that we'd be hearing cautious optimism from the lawyers, not the educator, but there you go, I'm wrong. So that's great to see. And of course, the ongoing work of the ARC Centre of Excellence for the Digital Child has a very crucial role to play in informing and hopefully driving some future development of law and policy in this space. So thank you. Please join me in thanking the panel members for their time. Thank you so much, and thank you all for being here. Before we finish, I'd like to hand over to Professor Julian Sefton-Green for some closing comments and remarks. Thank you.
Hello, everybody, and thank you very much, Anna, and also to the panel. I want to start by saying I'm extremely uncomfortable with the idea that anything good can come out of the United Kingdom. Okay, the whole of this, the narrative of the event has premised on the idea that the Children's Code is a great thing, and it clearly is a great thing. But the stories I heard about the way it got written are that it was a happy accident. That Emma may know more about this than I do, but that Baroness Kidron, there was a sort of opportunity to add something to a bit of legislation, and it was sort of made up, not entirely from nothing, but it wasn't. The point I want to make is that it was not the result of a careful, rational, sustained campaign. It was not the weight of democracy speaking in favour of progressive politics. Somebody took advantage of the opportunity, and thank goodness they did. And this is an important point because Reese, I think, used the phrase to talking about apathy experienced by young people in the face of what is a grotesque asymmetry in the relationship of the individual to the commercial and state actors who collect and commodify data about all of us, let alone children. The fact of the matter is that we then look for a proportionate response, so we turn to regulation as necessary and sufficient redresses and protections in these kind of situations. But I don't think, the point I want to leave you with in a way is that I don't think that the law in and of itself, forms of regulation, do the job completely. Lucy and my modest contribution to this debate is in the book over there, which is by no means perfect. I'm not being modest at all. Where we tried to collect stories from around the world where educators had developed programs and projects to teach young people about this grotesque asymmetry, about ways in which you might learn about the ways in which you are being datafied, and about possible strategies to intervene in that kind of process. It seems to me that we need to pay as much attention to these forms of education, to forms of school education and support for teachers and for schools, as we do to the legal conditions under which we're kind of all operating. I want to end by thanking the panel, thanking Emma for zooming in, to Sven, to Reese, to Cathrine, and especially to Anna for her exceptional work in mediating the discussion. I want to pay tribute to Luci Pangrazio, who magicked the idea out of thin air and put the panel together. And I especially also want to thank our colleague Loretta Watson, who made the event come together. And also many thanks to ACMI for entering into this partnership with the Centre of Excellence and enabling us to begin what I hope will be the beginning of a series of conversations to challenge and to inform and to bring all of us together in these kinds of venues. I want to invite you in advance to an unspecified date, either in October or November, when the next event in this series will be held, where we're going to bring together the EdTech industry and we're going to bring together stakeholders, developers and business interests into this discussion with educators, because we can't just talk amongst ourselves. And then finally, I want to ask you to join together in some refreshments which are available over there, and to get the chance to meet and talk amongst ourselves and to continue the conversation. So thank you very much.